Welcome to Limits Exhausted, Texas's Personal Injury Litigation Podcast.
Welcome back to Limits Exhausted, Texas Injury Litigation Podcast with Attorney Kiernan McAlpine, founder of McAlpine Law Firm and a board-certified specialist in personal injury trial law by the Texas Board of Legal Specialization. Kiernan has tried more than 40 cases to verdict and is frequently brought in by other attorneys to handle complex, high-exposure litigation involving 18-wheelers, catastrophic injuries, and wrongful death. I'm Shameika Rhymes, and today we're talking about judges, how trial lawyers should think about them, understand their tendencies, and tailor their strategy to the realities of how judges actually make decisions. Welcome back, Kiernan.
Thanks for having me, Shameika.
Well, let's talk about judges. How important is it for a trial lawyer to think like a judge when analyzing their own case?
This is up there with my absolute favorite topics to talk about. And I got to tell you, I've got some secret sauce on this subject that you'd have to call me to get me to talk about, but I'm going to cover things generally today on this, and I'm really excited to get into it. So this is something that trial lawyers almost never talk about. They focus on how to appeal to a jury. They might focus on mechanics of, deposing experts or things like that. But rarely, I mean rarely do I hear trial lawyers talk about how to get a judge on the same page as you about key issues. And I think that, is a little bit of a digression here. A lot of people talk about the distinction between a trial lawyer and a litigator. The litigator is the trial avoider. They want to settle. They want to minimize the risk of trial. Trial lawyer wants to go to trial. Well, I think that distinction is a little bit overhyped, shall we say. I think that in order to be a good trial lawyer, with almost no exceptions, you have to be a good litigator. To be a good litigator, do you have to be a good trial lawyer? Not necessarily, but so much of what moves the needle in your client's favor as a trial lawyer is litigation. And the judge is an extremely pivotal part of a case because the judge is going to be the gatekeeper of all the law issues and all the discretionary rulings that happen throughout the course of a case. And I believe that in order to be an exceptional advocate in trial and in court in general for your clients, it's extremely important for lawyers to be able to put on a judicial hat and set advocacy completely aside and think about a case in terms of how a judge has to look at it. Getting away from all of the, interested advocacy and think more neutrally and in a less attached way about the issues in a case. I cannot overstate how important I think that is as a skill for lawyers in general.
One, I'm going to take you up on that special sauce because I want to know more about that. So what does it actually mean to take your advocate hat off and approach an issue from a judicial mindset?
So the best way that I think I can explain this quickly is think about a lawsuit like a film. During the course of a lawsuit, the judge is going to alternate between being the director and being the main character, depending on what is happening. Sometimes the judge's job is to say, stand over there, roll tape, cut. And sometimes the judge is going to be the one driving the plot. And you have to know what you're dealing with in terms of what the issues are and what the law is. Because if you look at the law and you look at the jurisprudence and you look at the rules and the case law, judges are limited in what they can do, or they have vast discretion in what they can do. So generally speaking, it's very important to kind of have your advocacy tailored to what a judge is actually able to do in a given situation. Sometimes typically things wind up in kind of one of two different situations. Either there's a preordained outcome, legally somebody's advocating for what their client wants, but the judge can't really do anything about it because it's not the judge's decision, or it's 100% the judge's decision and there's almost nothing either side can do about it, and all you can try to do is appeal to the judge as the main character and be like, please help me out here. So, I mean, there's a lot of, discretion that judges have sometimes, and sometimes judges can't really do anything except one thing that the law tells them to do. So, early in my career, one of my supervising, I'm talking like really early in my career, like 13, 14 years ago, I had a supervising attorney tell me, Kier, stop focusing so much on all these legal mechanics and start advocating for what we want more. And, I've done some of that, but ultimately, my approach in dealing with judges is much more close to what can the judge really do here and what does the law say, and to try to dial in and look for where, where they can make discretionary rulings and where their hands are sort of tied by the law and the precedent. So I think it's vital.
Well, absolutely. Let me just say, I love how you come up with these examples like the film. I love that. It helps me understand. Yes. So judges are incredibly busy. So how should that reality shape the way we write and argue?
So I cannot stop talking about this to anybody that's willing to listen. Like in Harris County, Texas, and in Dallas County, Texas, which are like the two venues that I practice in the most, the trial judges in district court have 2,000 cases or more on their docket. That's a lot of cases. And trial judges are extremely busy. On a motion docket, on a Tuesday, they might have 30 motions. So it's incredibly important that lawyers in their writing, particularly, make things as brief and succinct and punchy as possible without sacrificing any kind of necessary completeness. Like I like to think about it like you've got 2 or 3 pages at most to tell the judge everything that they need to know to decide in your favor. If it has to be longer than that because you got to pin cite to depositions and you've got to cite all the cases and do all that legwork for, the completeness of the record, fine. But if you can't get the judge in their head arguing your case for you within 2 or 3 pages, you've lost them. So we really have to be ultra respectful of judges' time and understand, excuse me, we have to understand that judges do not have the time or the patience or the inclination to sift through incredibly lengthy legal papers and try to, discover what you're ultimately trying to say, like it's a mystery novel, right? We're not writing a mystery novel where 3/4 through they start to figure it out and then at the end, aha, they get it. No, we got to really hit hard fast so that we do not demand too much of their time, because I just, if I'm the judge and I've got 2,000 cases, like I'm giving you 10 minutes when I'm reading your papers. If it's 5 pages, I'm reading it for 10 minutes. If it's 25 pages, I'm reading it for 10 minutes because I don't have the bandwidth or the time to devote to some incredibly complicated, convoluted, and detailed presentation. Like we got to get to the point quickly. And I think that lawyers need to learn how to take off their advocacy hat and put on their judge hat and think about what would I do if I was the judge here, and just look at it from that perspective. It'll put you much more in alignment with the judge, and it'll make it a lot easier to get rulings in your favor when you need it.
I think that is great advice. So, if you're walking into court with a new judge, what are things that you most want to know about that judge?
Absolutely. And I hope you'll ask me follow-up questions to unpack these. So the first thing that I want to know is what their attitude is towards procedure. The second thing that I want to know is like how much they listen to the lawyers. And the third thing that I want to know is how they do voir dire and specifically challenges for cause during jury selection. Those I'd say are the top 3 most important things that I want to know, other than anything that's obvious that we can Google and find out just by researching the judge's basic background.
Okay. Well, let's talk about it. Let's break down number 1, the first one about the procedures. What are their attitude towards procedures? What are you specifically trying to discover?
We really need to know what a judge's attitude is towards procedure, because not every judge is as much of a stickler for procedure And not every judge is as capable of making kind of harsh, like technical legal rulings as every other one. Like there's a certain amount of mystique that a lawyer commands when they show up in court and they're like, Judge, I've got a really good case. I know it. I just need a little leeway. And the rules give judges leeway in many situations to manage their own docket, handle discovery, and so on. So, like certain things like deadlines have automatic exclusion under like Texas Rule of Civil Procedure 193.6, but it also says if there's good cause and no unfair surprise or prejudice, then the judge can let it slide. Some judges are much more prone to making like harsh technical legal rulings than other judges, and some judges are much more inclined to give lawyers latitude to be, for lack of a better term, human. And we really need to kind of know, in a certain sense, like how buttoned up we have to be and how perfectionistic and defensive we have to be about procedure in order to get the best outcomes with the judge, because not every judge has the same attitude about this by far. Some judges are much more prone to equity and to, giving lawyers leeway than others. Like when we're in federal court, we got to assume every judge is going to be a stickler for procedure, because when we ask for leeway, we very well might not get it.
Well, for the second part, do you adjust your approach depending on whether a judge tends to actively engage with lawyers or make decisions more independently?
Yeah, definitely. So some judge, like it's very important if you're preparing for a hearing or you're going into trial, you want to know how much the judge is actually going to listen to you when you argue. Is the judge going to give you an opportunity to argue your point, or is the judge going to kind of decide things based on their own kind of knowledge base that they already have? Like I tried a case, 18-wheeler case, week-long case in 2024, Harris County judge. She barely listened to anything that I said. Like she didn't give me much latitude to argue. To her credit, I think she knew what I was going to say pretty much without fail. So, and she made correct rulings pretty much the whole time. I don't have any complaints about it, but I wasn't really getting to argue. And I mean, one of the judges that I tried the most cases in front of when I was just getting started, like when I was getting board certified and I had to do 10 first chair trials to get board certified, I think 3 of them were in front of the same judge. It was like 10 years ago, where like defendants really liked trying cases in front of him because he was a big procedure stickler and would not give lawyers much leeway at all. And what was interesting about this judge was that he would decide like the same issue different ways depending on how the lawyers would argue it. So, if it's an issue that's, some judges will just handle it the same way every time. Does a police officer's narrative come into evidence or not? This judge would grant it or deny it depending on the reasoning that the lawyers use. So I could tell not only was he listening to what the lawyer said, but he was actually kind of evaluating their reasoning and informing his decision based off of that, which is a good thing, because in the sense that if you're prepared and have better arguments, you're more likely to win, but it also adds some unpredictability to it. So I definitely think that it's worth knowing, like, is the judge going to give me a chance to present my motion, or is the judge going to have read it and ask a couple questions and then rule? Like, we want to know kind of how much they're going to listen to the lawyers in order to figure out how we want to approach the judge.
Well, and for the third part that you mentioned, how critical is it to understand a judge's approach to voir dire? Things like challenges for cause, rehabilitation, and time pressure.
It is super critical. I mean, in a trial, voir dire is arguably, if not definitively, the most important part of the trial. So how the judge handles voir dire is absolutely vital information. How much time pressure are we going to be under? How much time do we have? Is the judge going to want a very short voir dire? Is the judge going to let us go on if we need it? Are they going to allow bench conferences with individual jurors to deal with rehabilitation issues or anything that, the potential juror seemed, ambivalent about? How likely are they to grant challenges for cause? Like, judges in Texas have a certain amount of discretion to say that, a juror should or shouldn't be excused for cause. Because like anybody that's tried cases can tell you, Sometimes there's a juror whose vibe is majorly biased in favor of one party or the other, like majorly biased vibes. And they'll say all this stuff. But then during like an effort to rehabilitate the juror by the lawyer that wants them on the jury, they'll kind of twist their arm and get them to say, well, if the judge tells you to follow the law and tells you that this is the law, are you going to do your best to be fair? And they'll be like, well, yeah, I guess so. So the judge can either be like, well, they said the magic words, they could be fair and they could follow the judge's instructions, or they can say, based on the totality of everything that was said, I don't believe that that's the case. They're just saying what they think they're supposed to say. And those decisions can go either way. So we need to know kind of, is the judge going to go for cause challenges more often than not and kind of err on the side of going with what sort of seems to be like the vibe or the sort of obvious judgment about the juror, or are they going to say, well, they said they could be fair, so I'm going to let them on? So those are the kind of things that we want to know. Is we want to know kind of, how is this judge going to deal with challenges for cause? It's super important. It's vital. It's one of the most important things.
At the end of the day, how valuable is predictability in a judge, and how does that impact your ability to advise clients?
Yeah, so most seasoned trial lawyers would probably tell you that predictability in a judge is an asset. And that might sound kind of weird if you don't work in this space, because you might think, well, if they're making similar rulings all the time, aren't they kind of not listening? Aren't they not treating different cases differently? Aren't they kind of closed-minded, you might think? But the fact is that as a lawyer, there is nothing, and I mean nothing, that is more important than your ability to give your client good advice. And when a judge is more on the predictable side, we can give our clients better advice because we can know more about what they're likely to do. The worst thing, in my experience anyway, for a trial lawyer is what I call the tale of two trials, which is a phrase that I made up kind of when I'm thinking through case strategy. It's headcanon. It means that if I have to go to trial in a case where there's some hotly disputed piece of evidence, and we don't know if the judge is going to let it in or not. We think they should let it in. We think they shouldn't. Depends on the case. But it's like, I have to prepare not for one case. I got to prepare for two cases. I got to have two opening statements. One if the evidence comes in, one if it doesn't. Because I don't know what's going to happen. And it's really hard to give clients good advice in that situation because we don't know. It'll make a big difference how they rule in pretrial. It's hard to say you should settle or you shouldn't if this is the offer, because if it goes one way, you shouldn't. And if it goes the other way, you should. It's very hard to give good advice. And when judges are unpredictable like that, it can be really tough. And that's something that's happened to me a couple of times. So what more predictability does is it takes us out of that situation. Now, I mean, honestly, though, to be fair, like we can also take advantage of that. Like if there's unpredictability, that means there's uncertainty. If there's uncertainty, there's risk. If there's risk, there's opportunity to resolve it. So we can, there's silver lining to it, but generally speaking, we want to be able to prepare for the trial that we're going to have rather than have to adapt in a rapidly changing situation to something that's like different from what we expected. So I think that, having predictability is one of the things that it's a big asset. Like federal court, I mentioned it earlier. A lot of plaintiff attorneys hate federal court. They don't want to be anywhere near it. I've come to kind of appreciate it because even though it is more difficult, there's a lot of reasons to not want to be in federal court if you can avoid it. But judges are sticklers and the rules are set up so the judge can dispose cases very efficiently. So you know what you're dealing with. You have to be completely buttoned up. You have to make filings very timely. You cannot underdo anything. Otherwise, you're going to wind up in big trouble in front of a judge who's not going to want to help you. So there's a level of predictability that comes from it that does help us know what we need to do and give our clients good advice. So I do think that predictability is pretty valuable. Yeah.
Well, thank you, Kiernan, so much for breaking this down and giving us an insider look at judges. And so don't forget, I'm going to hit you up to learn more about that secret sauce.
Absolutely. Please do. Thanks, Shameika.
Thank you. Well, that's it for today's episode of Limits Exhausted, Texas Injury Litigation Podcast. To learn more about Attorney Kiernan McAlpine and his work at McAlpine Law Firm, visit McAlpineLaw.com. Thanks for listening, and don't forget to like, leave a review, and subscribe to the show so you don't miss the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.